All right, good morning, everybody. Thank you all for joining us today. My name is Xiomara Palma. I'm the founder and CEO of Silvet HR consulting firm, helping small businesses with employee management and making a productive workplace. Before we get started, I'd like to give you a brief background about myself. I've been doing human resources for over 15 years now. The majority of my experience comes from the healthcare industry, but I do have probably almost half of my experience working with small businesses of various industries, different sizes, and in different states as well. I currently serve as an advisor as well at the Small Business Administration through their Small Business Development Center, and founder and CEO of Silvet HR, a boutique consulting firm. And what we do is basically we provide support and guidance to small businesses on regulations, compliance, best practices, how to attain and maintain a productive workforce. And in addition to that, we provide career development services to individuals. Before we begin, I'd like to cover a few housekeeping items. This webinar will be recorded and the recording available to all those that register for the webinar, along with the slides. I will be sharing the slides as well. If you have not already done so, please introduce yourself in the chat. I would like to provide this as an opportunity for folks to network with each other. Let us know the name of your business, how many employees you have, and what you're looking to get out of this webinar and any other topics you may be interested in. I will be opening it up for Q&A at the end of the webinar, but if you do have a question as I cover the slides, please do drop it in the chat. I just would not want anyone to forget what their question is at the end of the webinar. The intended audience for the webinar is for entrepreneurs and business owners that operate here in California. Also, any management administrators that work alongside the entrepreneurs supporting small to mid-sized companies, or any human resources support staff for those particular businesses. The agenda for today, I'll go ahead and cover minimum wage updates, laws, new laws that have gone into effect for 2025, their applicability and best practices. And I'll also cover a few resources and guidance for the Los Angeles fires, for those who may have been impacted. I'd like to provide some resources for that. And at the end, again, I'll open it up for a Q&A session. A brief disclaimer on this webinar is that, as many of you know, the nature of human resources is ever evolving. The topics that I cover are intended for informational purposes only, and they are not to be interpreted as legal advice or recommendations. Again, these are best practices relative to employing individuals in the Golden State. All right, with that being said, let's dive right in. So first up, we have the minimum wage increase. That's gone up to $16.50 an hour for the state of California. Now, I want you to keep in mind that there are many cities and municipalities that have their own minimum wage ordinances that far exceeds the state's minimum wage. And even when your business is not based within those city boundaries, but your employees perform work within those city boundaries for a few hours or minimum hours in a work week, you would probably need to pay them that applicable minimum wage for those ordinances. So for example, in the city of Los Angeles, we have a particular minimum wage. If you are a business located outside of the city of Los Angeles, but your employee comes and performs work within boundaries of the city of Los Angeles, you would need to provide them the city of Los Angeles minimum wage rate for those hours that they perform work within the city boundaries, if that makes sense. So there are many cities and municipalities, some unincorporated counties and areas that have their own ordinance, but for the state of California overall, the minimum wage has increased to $16.50 an hour. And this is an increase across the board. We used to have in prior years a breakdown of what they consider a smaller employer versus a larger employer. And Obviously, the smaller employers, minimum wage will be a little bit less than the larger employers. But now this year, it is the same minimum wage across the board for all businesses, all employers. With the minimum wage increase, we also see an increase in the minimum salary for salary exempt employees. What does that mean for many of you who may not know? So when you compensate somebody on an annual salary basis, you are basically saying this person is not an hourly employee, they're exempt from hourly wages and regulations, they're exempt from overtime, they're exempt from meal rest periods, and we're paying them an annual salary. Obviously, you got to make sure that the proper classification has been provided for those positions, that they meet the criteria. There are like 5 or 6 different criteria that need to be met in order for them to be within the position to be classified as salary employees. The part of it is that the minimum salary needs to be provided. So twice the state's minimum wage, which comes out to be $68,640. The other part of it is that at least 51% of their job duties must be within those 5 or 6 classification categories that I mentioned. And that is how you can properly classify somebody as a salary employee. So again, the minimum salary for a salary employee, a true classified salary employee, is $68,640. Now note that in addition to the local ordinances, we also have differences in industries, in particular the health industry and the fast food industry did see an increase or different minimum wages become effective last year in April for the fast food industry. As many of you know, the minimum wage there is $20 an hour. And for the healthcare industry, it has been triggered to increase in different facets. So the minimum wage there for the healthcare industry depends on the type of facility that you operate, and also it depends on whether or not some classifications, some job classifications work within your facility. So if you do have a facility in healthcare and fast food industries, I encourage you to further look into that, or you can reach out to me separately to get more clarification on that. Now, one law that we have seen change within the last couple of years, actually last year there were some changes, this year there are additional changes, is the crime victims leave. So this year, the new law redefines basically who is considered a victim, and that is defined as an individual against whom a qualifying act of violence is committed. And it also expands eligibility to include an employee who is a victim or whose family member is a victim of a qualifying act of violence for the safety of the employee while at work. The new bill requires that an employer inform each employee of their rights and provide a notice to new hires as well as all employees on an annual basis and anytime upon request, or any time that an employee informs an employer that the employee or their family member is a victim. The bill also requires a new poster, and the Labor Commissioner should be developing this poster with the deadline of July 1st of 2025. So keep an eye out for a new poster coming out that will need to be updated along with your other postings. So paid sick leave interaction with this leave. So if many have the misconception that paid sick leave only applies to employees when they are sick and or a qualifying reason, again within the realm of being ill or sick, but the paid sick leave law actually provides the time not only for when an employee is sick, but also for them to take time off to tend to to anything that is related to being a victim of a crime. So an employer cannot deny an employee the right to use their sick days or discharge them or demote them or basically retaliate or discriminate against any employee for using the sick days and or filing a complaint with the Department of Industrial Relations or alleging a violation or cooperating in an investigation or anything like that. So this is pretty protected. So again, paid sick leave hours can be utilized by employees when they need to take leave to tend to legal proceedings for them being something stemming from them being a victim of a crime or now a qualifying family member of a crime. And so just to be clear, who is a qualifying family member under the law? Now we have child, parent, grandparent, grandchild, sibling, spouse, domestic partner, or designated person. And designated person is actually something new that changed last year. And it basically means that the employee can designate anyone related by blood or whose association is the equivalent of a family relationship. So not only can they qualify for the victims, crime victims leave for that, but also this is something that changed for paid sick leave and also for California Family Rights Act leave. They now can designate someone, a designated person, to be able to take leave, and they have the right to do so. However, the employer may limit the employee to one designated person for 12-month period. Another area that changed for or got clarified for paid sick leave relative to the agricultural industry is that paid sick leave can be also utilized for when an employee is absent or cannot work due to smoke, heat, or flooding conditions created by a local or state emergency, including but not limited to when an employee's work site is closed, again, due to smoke, heat, or flooding conditions. So this was just a clarification that was added to the law, and employees can again tap into those paid sick leave hours as wage replacement when there is a disaster and they are losing work because there is a disaster. Now, a significant change we have seen now with the state disability insurance and paid family leave plans is that these two programs basically subsidize when an employee is not able to work because of a qualifying reason, either because their doctor deems that they are disabled and puts them on disability, or for paid family leave if they are taking, again, California Family Rights Act leave for either their own illness or for a qualifying family member, to take care of a qualifying family member. So essentially, we have seen through the years an increase on the amount of benefits that employees would get from these two programs. We are now at, this year, we're now at 70 to 90% of an employee's highest quarterly earned wages of what they would be actually receiving as benefit amounts from EDD, from the Employment Development Department. Previously, we were at 60 to 70%, and that was an increase actually many years ago. It used to be, I think, up to 50%. So again, we are seeing an increase in these benefits. And the other thing that was added or changed in regard to these benefits is that because sometimes there is a waiting period from EDD for employees to tap into these benefits, like a week period or a 2-week period, a lot of employers would have a policy that would require the employees take vacation time or any PTO available for them to be compensated for those for that time. So now the law basically restricts and prohibits an employer from requiring that employee take up to 2 weeks of PTO and vacation before receiving or as a condition to receiving any benefits from EDD. So, this is a change that needs to be reflected on all leave of absence policies. If you have if you have any verbiage in the policy in regards to requiring employees take time off, that is something that definitely does need to be updated now in the employee handbook and in your policies. Now we have also, this is actually good news for many small businesses, the leave claims mitigation. So essentially years back, the California Civil Rights Department created a mediation program for any employees that would file a claim with them, alleging any disputes in regards to leave of absences. The majority of them being leave of absences related to the California Family Rights Act. So leave of absence for their own disability, their own illness, or to care for a family member. And they had launched this program where they would mediate basically all these claims and try to mitigate the damage to small businesses. And so this program was basically piloted for a couple years. And this year it actually has been adopted as a permanent program in place to help small employers, so those with at least 5 to 19 employees, and then 5 because that's where most of the laws become applicable to employees. So anyone below that number would not have to provide these leave of absences anyway. So, so employers with at least 5 to 19 employees now can take advantage of this small employer mediation program should an employee have a dispute relative to leave of absence under the California Family Rights Act or under reproductive loss leave and bereavement leave. So those are the disputes that the program is designed to mitigate and help small employers kind of settle any claims and come in compliance with the law. So good news on that. That's a positive change for employers here in California. We also did see Senate Bill 399, which basically prohibits discrimination due to an employee declining to participate in employer-sponsored meetings or participating in, receiving, or listening to communication related to politics or religion. So these are, for example, like your Christmas parties or your team building events, or for example, if you have a group of employees and they are all discussing religion during sometime like during lunchtime or during an activity or anything like that. So now the employee has the right to decline to participate in those meetings. They cannot be required or mandatory under the law. So be mindful when you are scheduling any events, any employee events. If someone declines because they don't want to participate and they don't want to engage in any politics or religious discussions, then they do now have the right, legal right to actually decline that, and they cannot be discriminated against for doing so. We also did see Senate Bill 1100 go into effect. This new law basically prohibits employers from listing a driver's license as a preferred qualification for job candidates unless certain conditions are met. So basically, employers cannot include a statement in a job advertisement or posting or application or any other materials that an applicant must have a driver's license in order to, as a minimum requirement to be eligible, to be qualified for the job. There are exceptions to the rule, right? So one is unless the position requires or reasonably expects driving to be one of the main job functions of the position, and reasonably believes that using an alternative form of transportation would not be comparable in travel time or cost to the employer. So those are the only two exceptions now. So basically, yeah, you cannot require someone to have a driver's license as part of the main criteria qualifications for a position. And I want to just reiterate right here how important it is to make sure that all your job ads are actually in compliance and up to date with all requirements. In previous year, we have seen, with the equal pay laws, how and pay transparency laws, how important it is to be in compliance with the requirements now requiring that a lot of employers list the pay range or the pay rate on the job ad or the listing. So that's one criteria, but also now this other criteria. And believe it or not, there are many job ads out there that are not fully in compliance. And it's just so easy for somebody to come across your job ad. It's not in compliance. They just take a screenshot of it or save it somewhere and then file a claim for discrimination or anything like that. So I really hate to see small businesses be preyed on for these things. And this is something simple that can be prevented. So again, make sure that if you're, really correctly evaluate if the position does require, must have a driver's license to be able to list it on the job ad accordingly. All right, and we also did see Senate Bill 1137 go into effect. This basically prohibits discrimination not only based on a protected characteristic, but also on a combination of protected characteristics. So for those of you that may be asking yourselves, what is a protected characteristic? This is basically like all the protections that a person cannot be discriminated against for. So for example, race, age, gender, religion, right? There's a myriad, there's like almost 20 protected categories or characteristics here in the state of California. But this law basically, what it does is that instead of when there are multiple categories that a person is alleging that they were discriminated against, that they will take a look at those combined characteristics instead of looking at each one in isolation. So again, so just clarification here that when somebody makes allegations to being discriminated against for multiple characteristics, they will not be looked at in isolation, but they will be instead looked at as a combination of these characteristics and the impact that they had in order to determine whether a person or not was discriminated against. And this is a very interesting law, the Freelance Worker Protection Act. We are seeing more and more protections for independent contractors going to effect, mainly because, as many of you know, the employment laws are there to protect employees, but when someone is classified or misclassified as an independent contractor, they essentially lose most of the rights that the law provides for employees. So we're talking about wages, payment of wages. We're talking about benefits, paid sick leave. workers' compensation, all those rights that are afforded to employees are not afforded to independent contractors, because if someone is truly an independent contractor, they are operating on their own, they are negotiating their own rates, they are basically their own employer. Sometimes they may have their own workers' compensation insurance or errors omission insurance, things like that. So the law had not provided any protections. There were a few, like such as sexual harassment, that was still provided to independent contractors. But again, most of the laws didn't apply to them. So what this Freelance Worker Protection Act is aimed to do is that it now requires that when an employer hires a freelancer or an independent contractor for professional services worth $250 or more, now a contract it needs to be in writing to basically make sure that this person is going to get paid, because in recent years we have seen an increase where independent contractors are not being paid and were being taken advantage of. So this law aims to actually combat the independent contractors being taken advantage of. So now a contract needs to be in place that requires that it lists the names of the parties, the date, the dates, the services or the contract is in effect, the scope of services, so a listing of all the things that they are going to perform for your business, and payment information, right? So it must be, there must be a date specified in the contract for a payment date. And if it's not specified, then it is expected by default that the payment is due no later than 30 days after completion of the services. So again, this law is there to protect independent contractors. More and more, we have been seeing in recent years more laws to protect independent contractors. A few years back, we did see a law that it made it considered not paying an independent contractor above a certain amount. I think it was above 900 and some dollars. It was considered grand theft if they didn't compensate an independent contractor for that. So again, so we are seeing a lot of laws going to effect to extend some protections since we have seen an increase in the gig economy and a lot of freelancers within the industry. All right, so I hope by now everybody has the workplace violence prevention plan and has done their training. If you have not, please feel free to reach out and I can walk you through what the criteria and what those requirements are. But last year, all employers, or the majority, I'd say, there were a few exceptions. The majority of employers were required to set a workplace violence prevention plan in effect by July 1st, 2024. In addition to that, they were supposed to have trained their employees on the workplace violence prevention plan and additional criteria, and that was supposed to all have been done by July 1st, 2024. Now, this plan is like pretty fluid. So it's an evergreen plan. So it needs to be updated on a regular basis. It needs to be reviewed. There are things that need to be done. But one of the things that the Workplace Violence Prevention Plan did was that it created a provision where now an employer can request a temporary restraining order to secure an employee's safety. And in addition to that, it also created the temporary restraining order requirement to also seek protect an employee from harassment. So this is the part that becomes into effect as of January 1st, 2025, is the TRO, the temporary restraining order for those that are that suffer harassment in the workplace. And then like the definition of harassment basically means and knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Um, and the conduct must be something that causes a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress. So again, now the employers have the ability to seek a temporary restraining order for situations that fall under this definition. This is something that just came into effect as of January 1st. All right, and we did see a few changes or a few update on child labor laws. So this is essentially aimed to protect minors as more minors entering the workforce. But it basically, what this law does is it just wants to make sure that employers are in compliance with child labor laws. As many of you may know, these labor laws are pretty, they come with like pretty hefty penalties for violations of the laws. They provide all these protections for minors. So, what this new law did was basically it gave the option to employers to opt to voluntarily undertake a social compliance audit to make sure that they are again in compliance with the child labor laws. So if you do employ minors, I highly encourage you to take a look at what those laws are that apply to your business. Or simply you can reach out and I can provide some guidance on that. On the employment notices and posters, so we did see quite a few changes this year to the employment posters and notices. In particular, we're still pending to hear from the Labor Commissioner on the Crime Victims Leave poster. Also, we are seeing an update to the whistleblower posting, workers' compensation, discrimination notice, family and medical leave, and again, if you the minimum wage, right, the state minimum wage, but if you also fall under one of the city ordinances or county ordinances for minimum wage, you are also required to have a poster in a conspicuous place for all your employees to view, should they feel the need to view. So, along with these new labor law updates come obviously changes and updates that you would need to do to your policies and our employee handbook. So definitely we need to update the crime victims leave policy to make sure that it reflects all the new changes. It reflects all the new who's considered a family member under the law and the protections for crime victims leave, making sure that on your vacation and PTO policies, you are updating or you don't have any language that basically requires an employee to take vacation or PTO time as they go on their leave of absences, and properly assess independent contractor classification. So this is actually, I would say, out of all mistakes I see small businesses make, this would be like the number one mistake I see, that especially for startups, because I mean, it just makes sense, right? When you're starting out, you don't know if you're going to have an actual stable position for this person. So you're going to start someone out as an independent contractor, someone that can help you grow the business and things like that. But make sure that you are assessing whether or not that person is considered an independent contractor or an employee. And just for the record, because this could be like its own webinar. And actually, I have a lot of resources on my website at solvithr.com on independent contractors, just because in California, it is nearly impossible to classify someone as an independent contractor, and the penalties are pretty hefty. So if you do have someone as an independent contractor, make sure that you do have a contract in place, a written contract in place that covers all the criteria under the law, and making sure that you are compensating the independent contractors in accordance to that contract, or no later than 30 days after the work has been completed. You'll want to update all the postings and notices and ensure that your supervisors are aware of all these changes. So this is, again, another mistake I see made, is that the people that are, interacting the most with employees sometimes are the people that have the least information about the employee's rights and what an employee can and cannot do. And so a lot of these claims that come through about an employee not being able to tap into benefits or rights that they're entitled to stem out of supervisors or management's lack of knowledge of these laws and resources for employees of what they can and cannot do. So make sure that you are training your supervisors. They have all the information to know what is the employee's rights and the steps that they need to take to make sure the employee knows of all these rights. Obviously, as you're hiring new employees, making sure that they are being provided all the notices under the law to again make sure that you are in compliance. So a lot of these posters and notices are required to be provided upon hire. And just need to make sure that you cover yourself and at least have the employee acknowledge that they have received all these notices or brochures, so that you can have proof in your personnel records. And last, make sure that your job ads are, again, up to date and in compliance. So as I mentioned, we don't want to have any language there about requiring a driver's license unless it is critical for the position. It is considered an essential job function. And again, making sure that your job ads are in compliance with all the other regulations, the pay transparency, any discrimination laws, and things like that. Make sure that you are covered on that. So for help with employee handbooks and compliance, I do have an employee handbook I develop. I work closely with several law firms, and we have an employee handbook that ensures all employers are in compliance. We actually provide ongoing policy updates, make sure all the policies that are required by law are listed on there, such as sexual harassment, your lactation accommodation policy, any anti-discrimination, retaliation. And it's always good to have an employee handbook that basically establishes your company's culture, right? So it lets the employees know the rules of engagement, of what is acceptable in the workplace at your company and what is not, and the consequences for not abiding to your policies. And again, this is basically there to protect your business. Should you have to fire someone, should you have to discipline someone, you can always fall back onto your policies. And I can't stress enough how many times when an employee makes a claim against an employer and you're in front of a judge, the first question they will ask is, did you have a policy on this, and did the employee know about this policy? So again, although employee handbooks are not required by law, some policies are. It is always good to have one to protect your business. Now I'm offering a promo code, 10% off for any employee handbooks through March 1st of this year. So if you are interested, simply email me or reach out. I'll have my contact information on the next slide. but simply email me and reach out. Again, the promo code is ProtectMyBiz2025. And, we can talk about how to go about protecting your business and customizing an employee handbook for your business. Now, I want to leave with a few, providing a few resources and some guidance for those of you that may be in the Los Angeles area and may have been directly impacted by the fires. First of all, my heart goes out to all those that have been directly impacted, all the families, all the employees. This is a catastrophe we have never, ever seen. But no, a few things, some guidance to help if you have employees that are currently not working or your business has been negatively impacted by the fires. First and foremost, if you are operating and you're requiring employees to work, make sure that you're providing an N95 mask, especially if they work outdoors. Any exposure of over an hour outdoors requires them to wear a mask, or when the air quality index reaches 500, which has in some areas. So ensuring that you're providing the proper mask to protect the employees, that's first and foremost. If your business has been impacted, your employees are not working, your employees will be eligible for unemployment insurance. So definitely have the employees go to the EDD's website and file an unemployment insurance claim. This should be an event that's qualifiable for them to be eligible for unemployment insurance benefits. And just for making sure that you don't have anyone coming back and claiming that they were not compensated properly when these fires went into effect. Again, disaster hits very rapidly, and sometimes these are the last things we think about. But if you just want to cover reporting time pay. So if you have an employee that was actually working or reported to work the day that you had to evacuate and they didn't work their full shift, you are required to pay what's called reporting time pay. So a minimum of 2 hours, up to 4 hours for their shift. And again, so if there is a disaster, this is actually something that does not apply. But if you did, if you did have to have employees that were required to report and you were not directly impacted, but out of precaution, you sent them home or something like that, again, you're required to provide this reporting time pay. A couple other things I want to cover is that the Employment Development Department, along with the IRS, have provided some payroll tax relief. So for many employers, payroll tax payments are due January 15th of this month. And the IRS and EDD have deferred those payments. But however, employers do need to apply and they need to notify those agencies that they are going to be applying for the tax deferment. You just cannot, pay and not report that or not apply for the tax deferment. So go to EDD's website for that, and also to the IRS's website. And something to keep in mind is last year we did see a change to the wage theft notice. This is a notice that is required by the state of California to be provided to all new employees. Essentially picture like a job offer on a format. It lets the employees know their minimum salary, lets them know about their basic leave, how that's going to be paid, lets them know their work hours, things like that. But one thing that was added last year is that an employer was now required to let employees know of a disaster or an emergency. And so now with the disaster here in Los Angeles with the fires, If you are hiring or have any new hires, will be hiring in the near future, make sure that you are providing or filling out this form correctly and notifying those employees of the disaster in its respective section. Now, a few other updates. So FEMA is providing some assistance to those impacted. So make sure you check that out, disasterassistance.gov. The Small Business Administration as well is supporting small businesses with funding with low interest loans and idle loans. So make sure that you are checking that out. If you are impacted or know someone that's been directly impacted by the fires, for insurance claims, want to make sure that those affected, either employees or if it was your business yourself, the people are getting the proper resources, the proper links to prevent any scams from taking advantage of people. So make sure that you're providing those resources. And the Los Angeles Economic Development Center also providing some assistance for businesses that may have been impacted by the fires. So with that in mind, I will open it up for questions now. And want to share my contact information. Feel free to reach out if you have any questions. My direct email is solveithr123@gmail.com and our phone number. And if you'd like to schedule a consultation with me, I have my Calendly linked there. But now I will open it up for any questions. Anyone that has any inquiries, concerns, comments, suggestions? I am seeing someone say that they would like more information on the exempt salary portion of it. So when I cover the minimum wage portion, we talked about the also the minimum salary. So that's definitely something I will consider covering in a future webinar. It is a little bit more complicated than it seems. A lot of times, people are misclassified as exempt employees when they should be paid hourly. And again, it is based upon different job categories. So for professional, licensed professional, for executive, administrative, salespersons, those are the ones. I think I'm missing one or two more. Outside sales, inside sales people, and I think there might be one more. I'm escaping my mind, but essentially, those are kind of the categories that qualify for exempt employees. Obviously, if you have someone in management, that may qualify for the executive exemption. If you have someone that exercises independent judgment, they basically work with very minimal supervision. They are able to make decisions on their own, things like that. But if they are not within those categories, it's likely that they've been misclassified as salary employees. And again, like I said, to be in compliance with this, not only do they have to fall within those job classifications, but they also must be paid the minimum salary, and 51% of their job duties must fall under those, those 5 criteria, right? So they must exercise independent judgment. They are overseeing the enterprise. They are either a licensed professional, things like that. So yeah, I can definitely consider doing a webinar where I can take a deep dive into that classification, because I know it's something that comes up from time to time. Well, all right. I am not seeing any questions, so I would like to thank you all for joining me today. I will leave you with the gift of time. And again, if you do have any questions, feel free to reach out. Um, Feel free to reach out in or schedule a brief consultation with me. I can certainly walk you through, provide additional clarification on these items. But it's been a pleasure to be here with you all today, and I hope you keep enjoying the rest of your Sunday. Thank you very much, and Happy New Year, everyone. Thank you. Bye-bye.